afternoon, everybody. It's a privilege to introduce Dr. Howard Zonana, MD, and Madelon Baranoski, PhD. I'm glad we're working out the IT issues. This is going to be a great presentation. You know, we live in a renaissance of discharge upgrade practice in America, and Howard and Madelon are extremely important figures within this rebirth of widespread and robust advocacy for veterans with less than fully honorable discharges. In their capacity at Yale University, Howard and Madelon's fellows have worked closely with years of Yale law students that served as law student interns in Yale's Veterans Legal Services Clinic. Under Howard and Madelon's supervision, these fellows have also evaluated veterans who sought their expertise in conjunction with a discharge upgrade application to a Department of Defense or Department of Homeland Security Board of Review. Moreover, at the outset of their career, the students in the Yale Law Veterans Legal Services Clinic learn how to collaborate with expert witnesses ethically and how to implement the results of an expert witness's evaluation. Conversely, the fellows under Howard and Madelon's watch learn how to work with attorneys and veterans in a legal proceeding. So it's a two-way street. And I'm personally grateful to Howard and Madelon, not only because of the education I received as a graduate student working with one of their fellows on a case, but because of the continuing legal education that they provided to volunteer attorneys who participated in the Urban Justice Center Veteran Advocacy Project's Discharge Upgrade Clinic, and specifically the attorneys that belonged to the New York County Lawyers Association Discharge Upgrade Program. As the former pro bono coordinator at the Urban Justice Center, I saw firsthand some of the obstacles to effective collaboration between attorneys and forensic psychologists and psychiatrists. Howard and Madelon's contribution to the New York Bar's capacity for best-in-class discharge upgrade work is profound. There are many attorneys who might never have worked with an expert witness, much less a forensic psychologist or psychiatrist, and there were also attorneys who might have been skeptical about having their client evaluated by a forensic psychologist or psychiatrist. However, Howard and Madelon's outreach and education, plus volunteer and low-fee services by local forensic psychiatrists in New York City, fellows and students have allowed a sizable number of veterans in New York and elsewhere to receive forensic evaluations in conjunction with a discharge upgrade application. This, in part, is because with training, more advocates and attorneys are comfortable retaining forensic psychologists and psychiatrists, and these attorneys also know how to ethically interact with forensic professionals over the course of an evaluation and an application for that matter. The results of forensic evaluation are not always helpful to the veteran, but in some cases, they provide valuable evidence that ties mental illness back to specific points in a veteran's personal history. Often we see DOD and DHS boards of review are willing to stipulate that a veteran lives with mental illness, but they do not have enough, the boards do not have enough evidence to agree with a connection between the mental illness and past conduct. Professionals like Howard and Madelon are able to give an opinion about whether, in the past, a veteran lived with mental illness and whether that mental illness had an impact on the misconduct that led to a discharge. I will always be grateful for Howard and Madelon's impact on me personally and on the community of advocates who represent veterans with less than fully honorable discharges. And with that, I will give you a little of Howard and Madelon's biography. Dr. Madelon Visitanor Baranoski obtained a PhD in psychology at the University of Pennsylvania. Since 1999, she's been at the Yale School of Medicine, Law and Psychiatry Division. She's a professor of psychiatry and director of psychological services in the division. She established and now directs the New Haven Jail Diversion Program and developed community forensic services at a community mental health center. As faculty, she teaches medical students, residents, and fellows in both psychiatry specialties and psychology. She also teaches in the Yale Law School and participates in the Yale Law School clinics, including the Veterans and Immigration clinics, consulting to law students and conducting evaluations. She served on the Yale University Institutional Review Board for 20 years and is the chair of 4 of the review panels. Dr. Baranoski is a veteran and served in Vietnam as an Army nurse. Her current research, publications, and presentations are on vicarious trauma, risk assessment, and management strategies for persons with psychiatric disorders, and assessment and augmentation of decision-making in persons with cognitive limitations. Dr. Howard Zonana is a professor of psychiatry at Yale University School of Medicine and an adjunct professor of law at Yale Law School, where he co-teaches and consults in prison and immigration clinics and trial practice class. Dr. Zonana graduated from Syracuse University in 1958 and the Johns Hopkins Medical School in 1962. He interned with the Albert Einstein School of Medicine before performing a psychiatry residency at Harvard, Massachusetts Mental Health Center from 1963 to 1966. He became the training director for the Forensic Psychiatry Residency Program at Yale in 1979. Dr. Zonana currently serves and has served in several prominent board positions, including vice chair and chair of the American Board of Psychiatry and Neurology, Forensic Psychiatry Examination Committee, 1993 to 2008, the American Academy of Psychiatry and the Law, AAP, APPLE, APP, AAPL, past president and medical director from 1995 to 2013, the American Psychiatric Association, the APA, past chair, Council of Psychiatry and Law and Committee on Judicial Action and current member of the Committee on Judicial Action. Also, chair of the APA Task Force on Dangerous Sex Offenders in 1999, and chair of the Bioethics Committee at Yale New Haven Hospital, 1985 to 1999, and he's a present member. And with that, I'd like to turn it over to Dr. Zonana.
I want to start a little bit by telling you a little bit about our program, which was how this developed, because our model is not necessarily foreign to all of you around there and maybe a resource that can be tapped into. Our program is a forensic psychiatry fellowship program, which takes psychiatrists who've completed their basic training and gives them an extra year doing forensic evaluations in a wide variety of settings. We do a lot of competency to stand trial evaluations, we do criminal responsibility, and we do a number of civil cases like the veterans, like immigration, like children, and other areas like that. So our fellows spend a full year full-time, and now there are boards in forensic psychiatry. And one of the things, there are now about 40 or 45 training programs around the country that have set up and who potentially do this kind of stuff. I certainly know there's one in Oregon, and there's one in Colorado, and there are some other ones being contemplated in Washington. So let me just talk about what my experience is that in general, attorneys like the treating professional better than calling in somebody from the outside. And one of the problems of having a treating psychiatrist, now if a treating psychiatrist has seen somebody weekly for over a period of years, they certainly have a wealth of information that is not possible to reproduce, and in general, that can be a great resource. It certainly is for things like Social Security disability. The only problem, a number of problems come up, is that one of the ethical guidelines when you're treating someone is to do no harm. And that can be a problem if the treater disagrees with the patient about the extent or nature of the disability. And if he then writes a letter and testifies about it, we have certainly had examples where the attorney has said afterwards, you would have won the case, but your expert was terrible. And you can imagine what that will do to a therapeutic relationship when that occurs. And in general, most treating professionals, psychologists, psychiatrists, don't do additional psychological testing, often don't, as part of their practice, talk to a lot of collaterals. And so there can be conflicts in objectivity and the degree of data that is collected. Now, experts obviously have special abilities in the courtroom. They can offer opinions. We can rely on a variety of data that might otherwise be inadmissible. There's a lot of belief that experts can over-influence juries and judges. I'm not sure if I go along with that, but certainly there has been concern in the courtroom about what expert testimony comes in. And there have been a series of cases that have tried to make the judge the gatekeeper and somehow the screener of what is reliable evidence and what is not. And the guidelines have been difficult, especially in psychiatry, where there aren't the same general standardized tests or ability to have blood tests for our mental disorders. There's also a problem in what attorneys are looking for and what kind of evaluations we feel that we have to provide. So attorneys are generally looking to find an expert who is willing to support the litigant's position. They are advocates, and therefore they are looking for that. And so there is potentially a sort of adversarial bias in the kind of system that we operate in. I sort of euphemistically have three types here: the so-called hired guns, the team players, and those with sincere views. There are experts, unfortunately, who will tailor their evidence to provide the data that an attorney is looking for. Those are the so-called hired guns, and something that, at least in our profession, we try not to get ourselves in that kind of situation. Once you have a reputation like that, your credibility in the courtroom generally goes out the window. Also, attorneys will select experts whose views are known, and therefore they have more of a shot at being in the ballpark of what they're looking at. We all have some biases, and it's been my experience that psychiatrists and psychologists, when you work with attorneys, especially when you work with attorneys over a period of time, you tend to develop a relationship with the attorney, and you want to try to be somewhat helpful if you can. And that kind of, we call it transference in a certain way, can also bias an opinion. We get into this kind of work because the American Medical Association also allows us, and has it as an ethical guideline, that it is appropriate to assist in the administration of justice. That's what gets us into the courtroom in the beginning, because the do no harm axiom doesn't really hold. If you're testifying one side of a custody case, your opinion may do harm to either if it's your patient or one side or the other. And so there is not that kind of ability to follow through under that guideline. So this allows us to testify, so we have an ethical obligation to assist. They tell us the witness should not become an advocate or a partisan in the legal proceeding. We generally say you can be a partisan for your opinion, but not for the side. Medical witness should be adequately prepared and testify honestly. The attorney for the party who calls the physician as a witness should be informed of all favorable and unfavorable information and developed by the physician's evaluation of the case. It is unethical for a physician to accept compensation that is contingent on the outcome of the litigation, again, to try to avoid the hired gun bias. So the AMA has also got caught up in all the malpractice cases against physicians, and they began to feel that it was experts that were causing all these problems. And so they announced, and although I don't disagree with it, that expert witness testimony is the practice of medicine. The guidelines are different than for a treating psychiatrist, just like when you're doing research, the guidelines may be different, but it is part of the practice of medicine. And so complaints can be made to licensure boards if people feel your testimony is inadequate, beyond your expertise, or just false. So that's the problem of trying to avoid having people who just seem to do this in order to make a lot of money and to function in that kind of way. The medical societies have set up sanctions so that members can be expelled, and that's not unheard of by any means. The neurological surgeons reviewed 50 physicians over 15 years and censured, suspended, or expelled 10 members, and that was only subject to one legal challenge. So the medical groups takes this fairly seriously. Psychiatry has an ethical review board where complaints can be made as well. Okay, so let me just shift into, with these kinds of evaluations, we spend a lot of time in the beginning with the attorney trying to define what are the questions that really need to be answered and to make sure that those questions are psychiatrically relevant and that we can answer those. Sometimes attorneys just say, you know, just do a psych eval. Don't you know how to do that? But it's well worth spending the time, and it's not uncommon as data gets collected to change the question as the evaluation proceeds when data gets clear that something is not going to be viable. We generally will then review all the records from the military, police reports, prior treatment, and at times we've certainly had problems when attorneys feel that their guidelines somehow either require or make them not want to tell us all the information. That obviously can get to be bad problems, because if we do testify, then we can be asked, did we not know about that? And would our opinion change if we did know about it? So in general, this usually works fairly well with attorneys, and at least our group. I think we both mutually educate each other. We're not real experts on all of the law, obviously, and they're not experts in the kinds of details about what you can conclude from certain kinds of symptoms. There's a debate in our profession about whether you should let the attorneys review your draft reports. Some physicians feel that just opens you up to manipulation, and you shouldn't do it. If you want to change something, you can write an addendum. I have generally found that to be not a good practice. It has usually been my experience that if you share a draft, the attorney will often make corrections about our understanding of what we say, either the critical legal question is, or some of the facts even, and dates and things like that, so that I've found the review is usually very helpful. We'll get a little more into that, because attorneys then also want you to edit your report, and that can be a little more complicated. Generally, if there is going to be testimony, you certainly need to meet and prepare and go over with your expert what the questions are, because often attorneys ask questions expecting a certain kind of answer, but the way the questions are worded make it impossible for us to answer the questions in the way they're anticipating. So how you ask about diagnoses, how you ask about symptoms is critical. It has been my practice, and a number of forensic people I videotape all of my interviews. Some attorneys don't like that, some do. There's often a good deal of time between the time of my evaluation and a subsequent hearing or trial or something like that. And it is extremely useful for me to be able to review my interviews, because when questions get asked, I'm then up on it And I'm comfortable with having anybody review my tapes. If I don't feel my opinion can be justified by my interview, then I'm in the wrong ballpark. So attorneys also sometimes will call and say, I've been working on the case for 3 years, the trial's in 2 weeks, can you do an evaluation? As time has gone on, that's been easier and easier for me to answer and say it's impossible. And as I get into the details of it, you'll see why. These evaluations generally take from 1 to 3 months to complete, and you'll see why in a few minutes. Also, attorneys have learned that that you don't want to see a diagnosis of antisocial personality disorder. And so they often now object to doing some psychological testing where that might show up. And so they say, don't do any testing. Now, sometimes you may have enough information or things like that that you don't need to do it. But in general, it is better to do it because it offers some quasi-independent means of evaluating somebody. It's not just, as an attorney will say, you mean your report is just based on what he told you and not anything else? So these tests, a lot of them have been standardized against norms and will stand up in a number of areas. And generally, if the whiff of antisocial personality is in the air, the other side is going to raise it even if you don't put it in your report, asking you, do you think he meets the criteria and stuff like that. So you have to do the assessment. And generally, it's more critical as to whether or not you think somebody is not just antisocial, but whether they are psychopathic. And those are the sort of people that don't have any empathy and blame everybody else and stuff like that. So that can often be distinguished. And if someone is a heavy drug user and is just using the antisocial behavior to further their drug habit, you don't necessarily, under the DSM Diagnostic and Statistical Manual, have to diagnose them as antisocial. So there are a number of ways to deal with some of these things, but again, it's better to deal with it head on. So other areas where we have done, where questions come up is, and I've had a number of awful examples where someone says to me, well, let me tell you this off the record. So what do you do with information that you have that is supposedly off the record and is sort of critical information? Do you put it, how do you deal with that? How do you not? So I've generally found that the best response to those questions are, if you don't want me to know something, then don't tell me, because once I know about it, I can't forget it. I had a case where a lawyer jokingly said to a client in a sexual assault case, you know, if you were circumcised, there wouldn't be a case. The next week, the defendant went out and got a circumcision. And so the question was, you know, how do I deal with that? How does that come up? And I ended up, I talked with the defendant about it, who said he was always planning to get one, and I put it in the report. I figured it was up to the attorney to decide whether to use it or not. He did use it, and it didn't seem to undermine the defense. But in any event, those things can be problematic. The other thing, several other things come up is that as mental health experts, unlike most attorneys, if we hear about something that constitutes child abuse, we are mandated reporters. And so we generally tell people, evaluees, and we tell attorneys that if something happened in the past that the person should be told, and we tell them in our interviews, that don't give us any identifying names or ways in which it will be obvious who the person is. Because if there's no known child, then there's not an obligation to report. But attorneys have gotten very upset when somebody has said something, and then we have had to report it. Sometimes additional charges get added on and other things like that. So these are sort of nuanced kinds of things, but they're critical when they occur. So this is not the kind of evaluation where you can go in and spend an hour or two with somebody and write a report, and that's the end of it. These evaluations take a substantial amount of time to complete in an adequate fashion. You guys all often get, especially with the veterans, you get cartons of records from the military. And we generally have to read all of those as well. We can't just say, you know, you show us all the ones that are relevant. If we do that, then that opens us up to criticism. Obviously, we have to keep, when we testify, especially in federal courts, and most of the veterans' cases are in federal courts, we have to keep a record of testimonies. And if you're currently working for a VA, whether or not you're moonlighting, that represents a conflict of interest, and those people can't do evaluations, at least not for non-government. Now, one of the things that's problematic in this area is that the VA has terrific guidelines about how to do evaluations to assess for PTSD and things like that. The problem with it is that to do those evaluations and do the CAPS, which is a way of measuring each of the symptoms and stuff like that, takes anywhere from a half day just to do the CAPS, much less take a history and do all the rest. And the VA evaluators, because they're so far behind, often get about a couple of hours to do the whole evaluation. So in my point of view, there's no way that they can do an adequate evaluation in that period of time, or at least it's very hard to do in that period of time, unless the records are really crystal clear. So the kinds of questions that are appropriate are things like, does the evaluee have a family history of schizophrenia or a psychotic disorder? Is there a current diagnosis, whether the symptoms were manifest to a degree of 10% within 1 year of him being honorably discharged from the service? Does Y suffer from a psychiatric illness because of trauma experienced in the military? Was the misbehavior related to a mental disorder or combat exposure? Did the condition pre-exist to the time in service? A lot of the people we see have, you know, the service trauma is not the only trauma that they have experienced, and often have had other stuff in childhood. But if the service trauma was a substantial contributing factor to the exacerbation of symptoms, that's critical and can be sufficient to tie it to the military experience. Does the history and present symptoms indicate the presence of a disorder? And can you find any links between the current symptoms and incidents? And the extent to which the mental illness prevented him or her from holding gainful employment or maintaining meaningful relationships? Or more commonly now, does that lead to the use of substances, which often undermine somebody's ability to work and do other things? What's your opinion as to diagnosis and prognosis? The other thing to keep in mind is that these evaluations are not paid for by health insurance. as they're for legal purposes and not for treatment. Health insurance will only pay if the purpose is treatment. So at the outset of each interview, we have to let the person know what the status of confidentiality is. And in general, we say that your attorney has requested this evaluation, and therefore what we discuss is initially protected under attorney-client privilege or work product. If your attorney does not think that my conclusions are helpful, he or she will not ask for a report, and what we've talked about remains confidential. If a report is requested and used, then what we've talked about is no longer confidential and may become evidence in your case, and I may be asked to testify. So if you don't do that, then you haven't covered your adequate disclosure to do an evaluation, and the rest of your evaluation is worthless. So that's a critical endeavor. We generally expect people to review past medical records. We interview the evaluee. The norm is to conduct the interviews in 2 to 4 hour time blocks. As if you start doing 1 hour interviews alone, that won't be taken as substantial by a court, and you can't collect the data in a reasonable period of time. So we've gone anywhere from 2 to 2.5 to 6 hours, depending on the stamina of both the evaluee and the professional. And so we generally will spend 6 to 8 hours seeing somebody over the course of the evaluation. We review past medical records, psychological records, find out who are good collateral sources for information that can describe some of the evaluee's behavior and confirm or fill in the gaps. There are often thousands of pages of records. You've got to dictate or type out your notes. You've got to get quotes. You've got to do collateral interviews. You've got to do psychological testing. I just pulled out for this, I pulled out 4 of our reports over the past couple of years, and those reports vary from 14 to 40 pages in length. And the time spent on those was all between 30 and 40 hours of time to do this evaluation. Now, we have been, we work with the law school. We have our fellows go over and sit in on some of the classes where that's appropriate. And we've had a contract until this year when they upped the fee a little bit to do the whole evaluation for $1,500. And for the Veterans Clinic here at the VA, we do it for about $100. So we've been willing to sort of eat the cost for that and to provide that kind of service. But people in private practice are sometimes a little more reluctant to do that. So it's good if you can find a clinic, a training program, stuff like that, where both the fellows and the residents find these interesting cases. They're always learning something, and it's an attractive thing to do rather than spending, all these hours on something that you can't get paid for. So we do it. We think it's part of the public service. We're in a mental health center that deals with people who can't afford treatment, and so our mission is to try to continue that. And I think a number of law schools have programs like that. And that's how we got into it. All the clinics at the law school, which were based on law student interest, they have varied from representing the mentally ill in civil commitment hearings, to doing veterans, to doing immigration, and stuff like that. So it takes a lot of time. You've got to get all of these other testings done. And this is the sort of format of the way the reports go. You'll see all the documents reviewed, the confidentiality statement, at least in my regard, a good report, past background history, educational history, substance abuse, social and sexual development, military history, post-military relationships, past psychiatric medical history, medication, summary of psych testing, and the summary will include diagnostic impressions in answer to the specific questions that were being answered. Again, these are in federal jurisdictions, vary somewhat as rules, so you have to be careful about that. We do get into situations where attorneys ask that information be included or not included in the final report. And my general way to deal with that is if it's a standard part of our report that you expect to see in a psychiatric report, you can't leave it out. So if you say, don't put in the drug or alcohol history, I'm going to say that's an inadequate report that I can't sign off on. So, you know, I was doing an evaluation where 15 years before, the man who was accused of sexually assaulting his wife now had tied her in the basement and broke her arm, and the attorney asked me to leave that out of the report. Now, if I left it out of the report and the other side knew about it, I would get asked about it and, you know, asked me why I didn't put it in. And my credibility goes right out the window. So you can't leave out unfavorable relevant data, and the wording about how something goes in or how you describe it is more variable, and we have made a lot of editings when the lawyers have asked us to do so on stuff that's not as critical. We have worked both with the Yale Law School Clinic and the Connecticut Veterans Legal Center, which has attorneys who do this also. And it's been a wonderful experience for both sides. I just want to say a couple of things. A couple of cases we've had, for example, where the court has said one of our experts opined that the current PTSD diagnosis was related to an in-service stressor, where the VA had said it was not. They said he based his opinion on the interview of the veteran, review of the entire record, phone conversations with treating VA psychiatrists, and clinical testing. He supported his opinion with extensive rationale. He detailed how the veteran had symptoms meeting each criteria that constituted PTSD. He considered the possibility of malingering, but determined that it was not present based on a review of the record, clinical testing, and interview observations. He cited the particular manifestations being congruent with the stressor, and explained the mechanism of the current PTSD symptoms were a distorted pattern resulting in poor choices. So the judge said that based on this fully informed review, his opinion had substantial probative value. So even though the VA psychiatrist who reviewed the records but didn't examine the person again, he said that opinion was also probative, but he said the medical evidence of PTSD was then in relative equipoise. And when opinions are in equipoise, the doubt goes to the veteran, and so he got the benefits. So that's the kind of thing that comes up and why such extensive evaluations and reports are critical. We had another one where someone was given a adjustment disorder as a diagnosis, and was suggested that he be separated from the military. And the court pointed out that using adjustment disorder in that way was inappropriate because adjustment disorder rarely lasts longer than 6 months, and it's not a valid grounds for separating a soldier unless it's recurrent. So the details like that are critical, and why we benefit from both sides. So let me stop here, and if I'll let maybe Madeline talk, and then we can open it up for questions.
Good afternoon. I hope you can hear me. I'm usually loud enough in every other circumstance, so I hope I am today. Let me know if I'm not, I'll speak up. It's a pleasure to be here. And with Howard providing the theoretical background, I'm going to walk us through a case. Let me just move up to addressing the issue of what we can do for you and why forensic expertise in very specific ways matter. And the biggest reason for me is that diagnoses do not explain behavior, and all upgrades deal with issues of behavior. That's why they need an upgrade, because some behavior went wrong and they were received a less than honorable discharge. In some cases, even a dishonorable discharge. And so connecting the experience that they have and explaining that behavior and linking it to a disorder that could account for it in a way that reduces the responsibility of the veteran takes forensic expertise, besides clinical expertise. Howard talked about symptoms sometimes interfering with attorney-client collaboration. And then there are certain rules or practices that are in place. So the Board of Corrections for Medical Records, the Board of Correction or for Correction of Naval Records, they will seek DOD opinion, and knowing ahead of time what the pitfalls are or the challenges that might come up, where the weaknesses are in the argument, can better prepare you to put together a tighter case. So let's take a case, and this is a composite of cases that we've done. It does not identify any one veteran, and there's nothing confidential here that I'm going to present. This is a 24-year-old who joined the military at 20 after being accepted in the police training program, but because of budget cuts, there was no position for him. So he joined the military instead, and he had a successful first tour. He was in Guantanamo for a few months, he was in Africa for a few months, and he served in Afghanistan. He re-upped because he liked the military, and he indicated to his fiancée that he was planning to make a career of it. There were no disciplinary actions in his first tour of duty. He went to the health, or he had some health problems, but they were related to an ear infection. He sprained his ankle while on duty, and that was about it. On his second tour, he served in Africa. And in Africa, part of his job was to organize those who examined the bodies and prepared them for shipment back home. And he came back from that tour and began drinking. And he drank enough that he would show up on duty drunk. He was demoted, and then his rank was returned. He had made sergeant, and he was demoted again. And then he was finally detained because in the PX, he stole 2 packs of cigarettes. He had gone for mental health, but stormed out when he was told he had to wait. And on an examination by the mental health worker there, he never got to see a psychiatrist. He told the mental health worker that he had thought of hanging himself and had put a noose around his neck. That was reported upward, and he was given a tentative diagnosis of personality disorder. He showed up drunk again, went AWOL, and by his report, he was told if he accepted separation, they wouldn't seek a court-martial. And he accepted a less than honorable discharge. And he left the service at 23 years of age. He sought services a year later because of depression. He held low-functioning jobs, but mostly was out of work, and his drinking became enough of a problem that his family insisted that he seek treatment. And it was a year later when he finally sought services to see if he could get an upgrade and be more connected with the VA. On first glance, the connection between his military service and his symptoms is hard to put together. And when I do veteran assessment, I'm often reminded that the best thing about veteran assessments is the military record. And the worst thing about a veteran assessment is the military record. Because when it's complete, you have a very good narrative of what a person's adjustment looked like. But it is seen then as the total story. And what isn't there is often assumed to be unnecessary. So the fact that this young man never sought services and never had a psychiatric diagnosis except a potential personality problem became a problem. The assumption was he was adequately assessed and no one saw PTSD. Sent for assessment by his attorney, he was diagnosed with PTSD. He had a number of the symptoms that met criteria for PTSD, but his manifestation of those symptoms weren't necessarily classical. And whenever people say that, I always wonder, what do classical symptoms look like, right? So people have flashbacks in different ways. It isn't a clear connection to the original trauma in any way. It might be a disruption. And so this case demonstrates primary principles in the relevant to veterans system. First, mental health disorders predate any diagnosis, perhaps except for traumatic brain injury, when you know exactly when the traumatic brain injury occurred. But often the symptoms, the psychiatric symptoms, still take a while to emerge. But all mental illnesses begin first. So the fact that he was diagnosed years later does not prove that he didn't have PTSD earlier. Changes in function are the best indicators of the presence of a disorder. And I'll talk for a moment the importance of trajectory and something that you pay attention to when you're collecting information about your veteran. Finally, psychiatric disorders have no biomarkers that confirm or negate a diagnosis, right? So someone can say somebody has a personality disorder. There's no blood test to say they do. And there's no blood test to tell a psychiatrist or a psychologist to look someplace else. Psychiatric disorders are very different in that way from other medical disorders, where the lab tests point you into a direction and give confirming information. And finally, diagnosing a disorder requires time, an accurate history, and collateral. And one thing to watch for very carefully, the diagnosis of a personality disorder after one meeting should be suspect, because the diagnosis of a personality disorder is much more complicated to make. Behavioral trajectories are diagnostic aids. And if you follow here, pre-enlistment, this young man had no behavioral problems. He wasn't a saint, but no behavioral problems, no arrests. At deployment, he didn't. Post-deployment, there was a sharp increase. It wasn't the deployment where everybody suspected you would have PTSD. In fact, one of the arguments against his case and in favor of his malingering was that when he came back from Afghanistan the first time, he didn't have PTSD. He didn't show those symptoms. It did after he came back with the kind of tour that for him was the traumatic stressor. This is very different than a trajectory that looks like this, where a person has a repeated pattern independent of what happened in the military. And I often use this as a contrast in my report to describe that if this person were really someone who was antisocial or someone who was just getting in trouble by the law, then we ought to have seen it at other times. There were many opportunities to do that, but that's not the pattern that we see. These are the patterns that give substantial credibility to psychiatric diagnoses. And this is what a psychiatrist would use, looking at how things unfold over time. There are common challenges that we see in assessments with veterans. One is variations in disorders and the responses to military-related stress. So there isn't a uniform way to respond, and there may be disorders along the way that are diagnosed. So Dr. Zonana mentioned adjustment disorder. Adjustment disorder is often a first guess, because if it resolves on its own, it wouldn't be appropriate to diagnose someone with a greater problem. So they might look depressed, they might look anxious, but it resolves on its own. It would be called adjustment disorder. Over time, that can evolve in other things. Psychiatric disorders emerge over time, especially for young people in the military. At the crux of the chain of the time, their brain is changing. So young men and women who go in at 18 to 20, they still aren't fully developed in terms of their mental capacity. And as that changes, shifts in manifestation of disorders can also occur. Drug and alcohol use is often seen as an easy target to explain the problem. And so for this young man, that was the explanation. He was a drunk and he was willfully drinking. Whereas often alcohol and drug use, when it starts later post-trauma, is often a sign of a person trying to manage the internal agony and unrest. Functional decline, when it includes aggressive behavior, raises the scepter of antisocial behavior. And questions of malingering. And once malingering is questioned, there really needs to be a concerted effort to test for that and to either rule it in or rule it out. And I'll talk about malingering in a moment. So how are diagnoses made? There's a guide, the DSM-5, Diagnostic and Statistical Manual of Mental Disorders. There is a guide to follow. It is a guide. Persons can show a few of the disorders and maybe not have a full-blown diagnosis, but enough of the symptoms of that diagnosis that it'll still affect their function. Diagnoses are hypotheses that guide, sorry, I moved it too far forward, are hypotheses that guide the way a person or a treating physician will think about designing the treatment program. And if it works, then it confirms the diagnosis. If it doesn't, they propose another diagnosis. So it's an ongoing evaluation of a person and an analysis of what might be the problem. So let's look at post-traumatic stress disorder quickly. It's a cluster of symptoms in response to life-threatening events. There's re-experience, avoidance, and emotional dysregulation. And it's a hyper emotional dysregulation. So let's take our young man from the example. His intolerance for waiting for mental health, his reluctance to talk to his attorney, which was one of the problems. The attorney would set up an appointment, he'd come to the first one, miss the next one, not show, could be a sign of avoidance. Often the avoidance is an internal mental avoidance where the person doesn't want to think back at the very things that were so disruptive to them. The emotional dysregulation often gives rise to dysfunctional behaviors. And that's where you see that on that trajectory, where the problem behaviors suddenly emerge in response to the emotional dysregulation. And I remember asking, this one part is true about one veteran, why did you steal the cigarettes? He said, I couldn't stand waiting in line. I can't stand to be still. And that's that emotional dysregulation, the heightened awareness of stimuli around, the inability to manage it internally. Life experience can contribute with or to the rise of drug and alcohol abuse, irritability, even aggression can occur in the PTSD state, and depression and suicidal behaviors are there. It can be misdiagnosed. Initially, it's probably going to be diagnosed as adjustment disorder unless someone's really sharp at picking it up. And we have seen soldiers diagnosed with personality disorder, particularly antisocial and borderline personality disorder, which are often seen as the military as just problem behaviors when the PTSD part was missed. Traumatic brain injury gives rise to another, and we've learned a great deal on this last war that we've had that keeps going on, is that traumatic brain injury does not require a person to be knocked out. Percussive injury can disrupt function and cause a concussion. Concussions can create behavioral and brain responses that last for a long time. That is months and sometimes years in some cases. And so it isn't uncommon for a veteran to not recall being knocked out, and maybe never was, but was confused, was sort of wandering around, still was standing. When you're in a concussive state, you're not going to be able to figure out how long it was or what was going on about you. That would have to be observed by someone else. And so often for TBIs that did not include an open wound or a period of unconscious, there is not good data about the trauma. And so that needs to be pieced together. Sometimes imagery works, brain scans work. Often they don't. What we've learned from the football players, many of the signs of the repeated concussions are only evident on autopsy. And so the brain scans might not pick it up. A negative brain scan does not rule out percussive injury. In many cases, after a percussive injury, there's no change in the scan. And that's because of the almost crudeness of our scans, even though they're getting better as we go. Personality disorders, and I stick with this a little bit because I'll show you in a moment that with personality disorders, they're defined as an enduring and pervasive pattern of self-defeating behaviors. And the enduring and pervasive is important because that trajectory is one that will show the same kind of behavioral disruption before the military, or during the military, all through the military, and then after the military. It won't have that definition of being related to a traumatic experience or to a traumatic brain injury. And this is my slide that brings that forth. Personality disorders are the most problematic in veteran evaluations. And what we have done when they've come up is to evaluate how they were diagnosed. And that's an important key. If they were diagnosed by a psychiatrist who has seen a person over time for a long period of time with collateral information, I will give credence to the personality disorder. If, on the other hand, it occurs because a person presented for mental health services and was that day irritable or pushy or showed some other signs that ended up getting the person labeled, or if the veteran had in the military had reported feelings of suicide or maybe making attempts of suicide without an assessment of the level of depression, the validity of that diagnosis should be questioned. Very often people who are difficult to work with will end up with a personality disorder when it really could be another disorder. And I'll show you why in a moment. If you see in orange here, the characteristics that are associated with antisocial personality and borderline personality, and note, impulsivity, irritability, aggression, irresponsibility, but impulsivity, recklessness, suicide attempts, temper tantrums, right? If you look at PTSD, you see the same pattern in that emotional dysregulation. And so to make a diagnosis of personality disorder, a person has to be seen over time to rule out first the PTSD or the severe depression. Talk about adjustment disorder in a moment. It's a development of a disorder. It changes in affect and behavior will last 3 months of the stressor and resolve by 6 months post-stressor. Many veterans drop out of treatment before the end of that 6 months. And so the last remaining diagnosis will be the adjustment disorder. And so when you go to build your case, what you're looking at is what is really seen as a minor disorder. In fact, it's unfinished business because the person wasn't available for the next diagnosis. If you live in a rural state where people have difficulty accessing mental health, it won't be uncommon for people to be given an additional or an initial diagnosis, and then because of the lack of follow-up, the full diagnosis never gets formulated. The forensic assessment by the forensic psychiatrist can bring that out because there are markers of what it will look like when adjustment disorder moves to the other disorders. Military sexual trauma. You will have veterans with a very complex set of traumatic events that the attention has been focused, but still the assessments aren't quite clear. And there's a great deal of suspicion that many complaints are malingered. And one of the arguments that is put forth to support the malingering of military sexual trauma is the idea that you didn't say it when it happened. This is years later. Why are you telling us now? Why didn't you report it? Where's the evidence for reporting it? I think these cases, as the others, but in these cases in particular, a forensic psychiatrist will be very helpful to you because the recognition that reporting sexual trauma requires a sense of safety, that there won't be retaliation for reporting it, and also enough of a sense of self that the embarrassment and shame associated with sexual trauma has waned enough that a person can stand up and even articulate what happened. So these are the cases that we've worked the hardest on, and I asked Dr. Zonana, but I bet the 40-page analysis might have been one of these. Psychological trauma, sexual trauma, right, is sexual trauma. And the military recognizes that, the VA recognizes that, but putting it together in a convincing argument requires a very careful narrative, life narrative of the person's expectation, the person's previous experience, and the post-traumatic experience and level of function. Many will not meet full criteria for PTSD, but might have enduring effects. And part of that is a function of our diagnosis in the DSM-5, which requires a certain level of trauma to be commonly recognized, rather than a sense of a diathesis stress with a person who feels violated in a way based on background, based on expectations. Substance abuse and arrest are red flags that need to be understood and addressed. And your forensic psychiatrist or psychologist can tell you whether or not they're going to continue to be a problem or whether they can be connected with and explained by one of the diagnoses. So in the example that I gave, the explanation for his heavy drinking was an unresolved PTSD and a sense of failure on top of that. So it was PTSD plus severe depression. The arrests, again, looking at the trajectory will give you the best idea of whether you're looking at a case that can be built on that narrative, that sense of who they were before as a person, what expectation they had of the military, and then after what happened, what do they look like? How are they different? Why has that continued? Again, if you're in a rural state, access to mental health when you come out of the military, access to jobs, access to family support may play a major role in the level of recovery. And I'll give you one example. This wasn't a PTSD case, it was a schizophrenia case where the VA argued that the person didn't have schizophrenia while they were in the military, that it came a long time after. Because while in the military, the person began to show a decline in function, could no longer do the job they were doing, was not arrested, did have an honorable discharge, came home, and then didn't leave his mother's basement for 4 years. He wouldn't go outside. He was very suspicious. He painted the windows black. Mother couldn't get him to go for therapy, even though he qualified for an assessment at the VA. When he finally did go, and it was because the family was selling the house, the VA said, well, it started later. He came out, he had an honorable discharge. It didn't happen until later. In the forensic psychiatry assessment, it was very clear that the schizophrenia was present the day he left the military and for months prior to that, and that actually the onset of schizophrenia, with the strong family history he had, was exactly about the time schizophrenia would have emerged for him at the age of 21. And he showed evidence of that, and he actually had sought health care for it because of odd somatic complaints that were just seen as either trying to get out of duty or a vague GI upset, when his complaints were about the worms that were implanted in me from the meals that are taken off the economy, and they're not spraying here. And that was his complaint. That was reported, not appreciated, because he didn't go back. And that was a case where we were able to get him service connected, because the schizophrenia did happen there. Pay attention to schizophrenia, again, especially in a rural community where access to care is low and the willingness to seek out treatment might be low as well. I see, I keep clicking on the wrong space there. And finally, malingering. And let's be clear what malingering is. Malingering is defined as the willful presentation of false symptoms for benefit. And so often, if a veteran is trying to get benefits and you malinger symptoms, and you can get benefits, but it's active malingering of symptoms. And so it's faking. There are hallmarks of fake symptoms in PTSD, in schizophrenia, in depression. And those hallmarks often capture what TB renditions of those disorders look like. Malingering is not the same as refusing to answer questions or a refusal to talk to you. That's not the same as malingering. Malingering takes a lot of energy and a lot of focus. And the psychological testing is very effective here in identifying whether malingering exists or does not exist. And I'm really careful when we teach people to do malingering tests to say, if you find it, you gotta challenge it in the person to see what's underneath. Because you can find malingering, it doesn't tell you they're mentally healthy underneath. You might just be getting somebody who's exaggerating symptoms rather than making them up. The tests for malingering are better than brief observation, where in brief observation, a person's enthusiasm to complain might be falsely understood as exaggeration or malingering. Okay, so what does assessments require? Several meetings. Even if you do a 6-hour meeting, you kind of need to go back and find out what they thought about between the two times. What did they forget to tell you? And I recommend this to lawyers too. Give your clients the permission to mix things up and get it wrong so they can tell you they made a mistake in what they said. Give them that permission. And we certainly give them that permission. You need adequate collateral if you can get it. Past records beyond the military. Contact with those who know the client best. And that's beyond treaters. And then psych testing, which I endorse, obviously. And early discussions with the attorney to see whether or not the narrative that's evolving for the forensic expert is one that the attorney has seen as well. Or what else? And we don't interfere with attorney-client privilege. You have a right to keep that privilege very, very separate. But as we talk about what we're saying, you can identify whether or not that matches or even explain some of the experiences that you've had. And what you get, and Howard talked about this, so I'm not going to spend time, I'm going to stop now, except for the very last bullet. We are never not helpful to you. We might not be helpful in the way you want us to be helpful to you. But when we say to you, you know what, from our perspective and our testing, you don't have a case. You'll know why and where the problems are. And knowing that will help you then prepare and change your strategy, perhaps. All right, I'm going to stop.
So I'd like to open it up to the audience and who'd like to anyone who would like to ask some questions.
Yes, for either of you, the VA's avoidance of service connection for things like personality disorder generally is because it's a developmental sort of thing, therefore not caused or influenced by the military. But it seems in what I've studied about personality disorders, they appear about the same time that a typical person is in the military service. So I was wondering if there's any science or substance to an argument that, in effect, as the twig is bent, so grows the tree. The military experience can incite the personality disorder coming into effect, regardless of trauma or any other causation.
One of the factors that makes that hard is that our diagnostic manual says since these are long-lasting traits, in general, one shouldn't make a personality diagnosis before the age of 18. So that limits that. There are obviously some people who, in retrospect, look antisocial since they were 6 and continue to do that. But by and large, we don't make personality diagnoses until after they've passed through teenage and have had a chance to see what settles in and what disappears.
I'll just add one other thing. So all disorders are on a spectrum. So there are some people who are antisocial and they were as a child, even if you don't diagnose it, and nothing was going to change that, right? There are others with some tendencies of a disorder, and in the right environment, they might never have emerged to a level of a disorder. But what the military environment is, it's often a separation from supportive environments and familiarity. If you have a nexus, the environment can often pull out, help that develop. I do understand the VA's point. I also think, though, if you overdiagnose it, you lose your point, because if you're diagnosing personality disorder when that's not the problem, it giving rise to the wrong base for understanding the disorder.
In my case, where they had the adjustment disorder, he was complaining of nightmares, and he was just told, you're having dreams, not nightmares. When he left the military and went to the VA, within 175 days, they immediately diagnosed PTSD.
I was just wondering if you could share any tips for everyone here about working with people who have experienced trauma and how to talk to them about it. Any just practical tips for attorneys, given that you are both such experts?
One of the most common things that I've run across with law students as well as attorneys is that when you start to ask about the details of the trauma, that often acts as a stimulus to re-evoke symptoms. And so it's very important for you to tell somebody that you're asking about things that have been traumatic, and they may find that in the next week or so that they're starting to have nightmares or other symptoms again. And if they should let you know that, and that you can try and pace and get the history in a way that maybe allows for some spread out of time or other things. But you can get a real exacerbation of symptoms as you're just taking the history. So you need to let them know about that and to ask them about it when you see them the next time. Did you have any reaction to us talking about this stuff? And sometimes people do need to get into treatment. They're not in treatment.
Another thing is to give them a choice of what area to focus on. So some in the beginning would rather you go through background or so on, and a simpler one till they have rapport with you, and then move into the other areas. By giving them choice, they're limiting their exposure. Eventually, they do have to talk about the trauma, but they don't have to do it at the very beginning of the interaction.
If they have a traumatic brain injury, I mean, do people often, is that confused with symptoms of intoxication? Have you seen that?
So yes, that can happen. And it depends a little bit on what part of the brain was injured. Okay, so what if your balance is off because it was the parietal part of your brain? Then later, if that hasn't fully recovered, slurred speech sometimes is a cloudiness that a person feels. That could endure for a long time, and someone could say that looks like intoxication, someone who isn't informed. It's very easy to see if somebody's under the influence. For example, if you go to a mental health, you just do a urine and you can tell, are there drugs on board or a breathalyzer? And so rather than assuming that should be checked. But it's true, it depends on what part of the brain was injured.
It can obviously be harder if somebody's drinking on top of a traumatic brain injury.
Yeah.
I'd like to have your opinion on cross-cultural people that have different worldviews than the majority culture, like Native American or Hispanic or Asian soldiers that come from a different background. And they may have different behaviors and different beliefs. And what do you do about that when you talk about personality disorders?
When dealing with different cultures, at times there are often language problems, and we get translators and try to get people who know the culture as well. Symptoms vary according to culture. Some people, like in Africa, will have more somatic symptoms like stomach aches and things like that related to depression than in this country. So you do need to either consult with someone or bring in someone to do the evaluation who knows the culture. That certainly is the best. And there are often a lot of subtle language problems. So people who speak dialects and stuff like that, we've certainly learned in the immigration setting that can be enormously problematic when they have a translator on the phone who doesn't know the dialect.
I'm going to ask a question, Dr. Baranoski and Dr. Zonana. Can you speak a little bit about any experiences that you or your fellows have had acting as expert witnesses in discharge review board hearings, or potentially the rare hearing before the boards for correction of military records or the board for correction of naval records? I know that in my experience, when we're speaking to programs in forensic psychology or psychiatry about the benefits of a partnership, one of those is that fellows get the opportunity to potentially, engage in, to testify in an administrative hearing on behalf of a veteran. So can you talk a little bit about either your experiences before the DoD boards of review or the kind of experiences that your fellows are having?
Oh, one we just did last year with the VCNR. And so I'll tell you what was most helpful. Practice with the attorneys, because the direct testimony allowed me to shape the story before the questions came from the board. And so that was very, very important. The one downside is, I guess it isn't unusual for testimony to be telephonic. And I don't like that, because I can't see then how the person is hearing what I say. But I think that comes up in part because of the distance travel. And so that was one experience. We've had boards that have wanted to hear just very specific questions. They often focus for our fellows on malingering and why it wasn't so. And I think Howard mentioned earlier, when given the weight to the treating physician is also an issue that comes up. So if the VA has identified a problem, the question once was very direct. And so why do you think you know more than that, to one of our fellows? Did that help? I mean, there were a number of other things that came up, but those were the issues that I identified, that the board has a very specific set of needs and they go after that.
I want to ask about person discharged for homosexual conduct. One of the considerations that we're told that the board takes into consideration is what corrective action have you taken, to fix the situation? What do you do with that? The person that was discharged for the military, like if they're coming back to do a discharge upgrade, one of the considerations for the board is what have they done for corrective action to fix the situation that they were discharged for?
Well, it would have to be related to some specific behavior or some problem. I don't think it's just the homosexuality per se. I don't think there's any expectation that that has to get changed or fixed.
And the main, sorry, and Howard and Madeline, if you just want to jump on this, I'd say the main thing that's helping gay, lesbian, and bisexual service members who receive less than fully honorable discharges was the legislative change, was the change in the law that the prohibition ended. And as we were saying before, in terms of the arguments for discharge upgrades, that the law has changed is fundamentally is opening doors for relief. But do you have anything you want to add to that question? Sorry to jump in there on that, Dr. Zonana and Dr. Baranoski.
I mean, that's certainly something that the Psychiatric Association has long argued for and lobbied for in the military and elsewhere. So that's one area where there's been a sea change in the policies, except for some recent wrinkles that are coming up again.
Okay, we're going to wrap up our end unless either of you have anything further.
No, just thank you for having us.
Yes.
So, then thank you.